How do you deal with a Telephone Consumer Protection Act demand or lawsuit? Well, first, you should engage TCPA counsel way ahead of time to prevent such claims in the first place. A good TCPA lawyer can help you understand do not call lists, cell phones, dialers, and texting rules. They can help you obtain proper consent if written consent is needed. If you are in the situation of already being served with a TCPA lawsuit, don't panic, but act quickly. Immediately preserve all relevant evidence. In many TCPA cases, this normally involves identifying and saving your call logs or CDRs, contracts with your vendors who may have been involved, correspondence, policy and procedure type documents, documentation regarding your do not call and cell phone scrubbing habits, scripts, etc. Preserve all that documentation as you may need it later, and you're required to do so under the law. Next, investigate your exposure thoroughly. Note your answer or motion deadline, calendar that, and request an extension if needed. Many plaintiffs' attorneys and their clients will allow a short extension, especially if they know you are going to engage with them on the case and not ignore them. Be aware, however, in many courts, especially in federal court, you cannot always just rely on an informal extension from plaintiff's counsel. Often there is some sort of motion in proposed order or stipulation that needs to be filed with the court to make that extension official. This fact means you normally need to get your counsel involved early on. Your counsel can also help you assess your exposure. Did you make a mistake? If so, what? Correct it. How can you prevent that mistake in the future? What documentation exists? If you have exposure, consider an early settlement. If the plaintiff would take, for example, less money than the cost of the filing of an initial answer, you may want to seriously consider putting that money toward a settlement rather than toward your lawyers. Next, if you do decide you need to fight the case, fight aggressively. Consider having your counsel file an aggressive motion to dismiss the case based on multiple grounds, rather than merely a short boilerplate answer. Put them on the defense quickly. For example, some TCPA firms will file motions to dismiss based upon the 2016 U.S. Supreme Court decision in Spokio, which held that TCPA plaintiffs generally need to have suffered actual concrete harm in order to have standing to sue. Also, you might consider a motion to dismiss if the plaintiff's complaint is a little slim or sloppy, doesn't have the plaintiff's telephone number, the dates and times of the calls, the type of call made, or whether the calls were answered, etc. If they didn't do a good job pleading the specific facts of their case, motion to dismiss. Also, some courts have stayed TCPA cases pending decisions in important FCC or TCPA lawsuits or appeals that are still pending. In any event, if you respond quickly and appropriately and aggressively, your company will be in good hands, you'll get through it, and you'll be back on the phones in no time.